In the matter of State versus Gary Twiggs, may we have appearances, please? Welcome, counsel. And many of the arguments have been aired in the prior case. You're welcome to adopt those if you like. Ms. Lichter, please go ahead.
Morning again, Your Honors. I'd like to request a 2-minute rebuttal if necessary.
Okay.
And I incorporate my arguments that I made in Jones. And I will say here that, again, the issue is what the definition of the word actor in the tolling statute, N.J.S.A. 2C1-C, is. The state asked this court to apply the plain language again of the statutory definition for actor for the tolling statute, once again meaning any natural person under 2C1-14G. By the statute's explicit language, the statute of limitations thus told when a prosecution for offense is supported by physical evidence that identifies any natural person. This court should give that definition, adopted and enacted by the legislature, its full effect. Though other sections of the criminal code have specifically stated different definitions for actor, the tolling statute contains no other definition. When the plain language clearly indicates the meaning of the statute, the interpretive task is thus complete. Here, co-defendant Tracy is a natural person. His DNA recovered from the robbery scene in 2009 produced no match when it was run through CODIS. However, in 2014, a match necessary to establish the identity of co-defendant Tracy occurred. That was the time when the state came into possession of the evidence necessary to establish the identity of the actor or any natural person. Until this time, the statute of limitations was told. Co-defendant Tracy's confession as to the crime and implication of defendant Twiggs occurred within the 5-year statute of limitations period. This led to the follow-up investigation that ultimately led to the arrest of defendant Twiggs. Thus, defendant Twiggs' indictment, also filed within the statutory limit, should be reinstated. There's no reason to interpret the language of the actor here any more narrowly than what it was interpreted in Rumblin. If actor in the nearest statute includes accomplices as well as principals, then there is no reason that accomplice would not also be included here. Under either definition, the statute of limitations should have been told here. Co-defendant Tracy is, of course, a natural person, and under Rumblin's definition of actor, a defendant to the charge of conspiracy to commit robbery. The prosecution against him and defendant is supported by physical evidence that identifies Tracy. The statute of limitations should have been told until the state acquired the DNA evidence necessary to identify Tracy. It is important to note that the state's position is supported by the plain language of the statute, legislative history, and case law. However, defendant's proposed definition of actor, quote, persons whose DNA directly identifies them as criminal actors, is not plainly or explicitly defined in the statute or case law. Such a definition is absent from the statute. Further, the legislature originally drafted the tolling statute to read that if the identity of the person who committed the crime is unknown when the crime is committed, and the physical evidence is collected which can be tested for its DNA characteristics and used to identify the person who committed the crime, a prosecution for the crime may commence at any time. But the legislature modified the bill for a broader definition. The enacted statute provided that the prosecution must only be supported by DNA or fingerprint evidence that identifies the actor, which reflects the legislature's intent for a broader definition of actor than originally proposed, and certainly a broader definition than the one proposed by defendant. Under defendant's definition, the statute of limitations would only be told in one very limited circumstance. When the state has physical evidence from a crime, the physical evidence matches the DNA from a suspect, and the suspect is the sole defendant in an indictment for an offense. If this is what the legislature intended, they would have drafted the statute to plainly say